Welcome back, you guys. We're starting a stream for Daybell. If you missed the last few minutes of the stream for the Karen Reed trial, then well, if you caught it, then you know. If you missed it, you're getting ready to find out that there's they're your binoculars. There's a little bit of a hiccup. Is that even what we would call it? In the Daybell trial. So there was some clerical errors on the indictment, and at 4:30 Eastern, Judge Boyce will be making a decision about dismissing the murder charge for JJ Vallow against Chad Daybell. So, based on that clerical error. Took a few minutes. I've calmed myself down. I made a set of binoculars out of empty toilet paper roll tubes with some tape. So she's a happy camper with her toilet paper roll binoculars. We have I found online Nate Eaton. There's a video he's put out. It's not very long. It's just a few minutes. I think maybe 10 minutes-ish long. And he interviews Larry Woodcock about this news. So let's watch that and we'll get caught up on what this means. I saw you sent something, QB, but I haven't opened it yet. Oh, wow. Okay. It wasn't Pryor that brought it up. Who brought it up? Okay. Oh, the judge. He's the one that brought it up. Okay. Wow. Wow. All right. Well, let's watch this. I'm going to mute my microphone because my neighbors decided to mow the yard. So hopefully can you guys hear the lawnmower in the background? Means it may not be prejudicial, so they could let them amend it. I'm hoping. All right, I'm going to mute my mic and we're going to watch this interview. So let's go.
Who's responsible for the death of a child? JJ
Well, I didn't realize that Nate didn't have the microphone on. Crap. And the volume is up as high as it'll go. I don't know. We can make out anything he says. Hopefully he realizes the microphone's off and turns it back on.
If for some reason the
charge against JJ has to be dropped, or he has to be acquitted on that because of that technical issue, would you still be able to handle, him being convicted on the other charges, even though he wasn't included?
Oh, absolutely. Right now, it's very confusing. I'm very disappointed. I'm very hurt. I don't know what the ruling is going to be. Nobody does. But I just hope, as I've said all along, I just want a fair, just, and honorable and righteous ruling by the court. I don't even know what to say. Kay and I were planning granddaughter's graduation. Just wanted to be home 2 days, lie down, fly back, I'll be here Monday morning. Thank you. The defense is going to put on that. I don't know where it stands. It's very disappointing to me, but I will be strong. I will be confident that this issue will be worked out, and I hope that the murder of JJ will be kept in evidence.
And I'm not sure, and I apologize for coming into this late, but if this does lead to an acquittal on that charge, do you still think justice is served for JJ?
It wasn't playlight. It was the murder of children. JJ was the most innocent of all, a 7-year-old autistic child. And the defense is trying to say that it didn't happen. From my perspective, no. He matters. This whole country, this whole world has fallen in love with JJ, with Tylee, with him. And to me, the part of this is JJ Vallow. JJ was innocent. It's more innocent than you be. Being accepted autistic child did it. And then at the stage of the game, it seemed like the defense is saying, oh, he doesn't matter. Maybe I'm wrong. But whatever it is, it is. And I feel that justice will be served. Thank you.
Thank you.
Thank you. Okay, so I'm going to fill you in on what happened just moments ago. Big news here at the courthouse. I'm going to go over here to get out of the traffic. The prosecution rested this morning, and then the defense argued kind of a procedural type of motion that the state didn't prove their case, and that that Chad Daybell should be acquitted. This is a standard type of thing that that happens in most cases. Judge Boyce noted that on the indictment on count 4 on the murder of JJ, the state has on the amended indictment that JJ died between September 8th and 9th. He didn't. He died between September 22nd and 23rd. And so the state has rested. And if you look at the indictment, the state did not prove that JJ died between the 8th and 9th. The state may have proved, says they proved that he died between September 22nd and 23rd. Nobody caught it. Nobody caught it until today. And so the state asked if they could come back Monday morning and address the issue. John Pryor said, no, the defense is starting Monday morning. I should have a right to know what I'm arguing. Am I arguing that charge or not? Judge Boyce has given the state 2 hours to come up with a response on how they can possibly amend the indictment if they can. Remember, this was an indictment that was already filed and amended. So many of you are confused. Let me just give you the brief rundown about what happened. The state rested today. After the state rested, John Pryor argued a relatively routine motion saying that the state didn't prove their case and the charges should be dropped. Judge Boyce said, I'm ready to rule, but I have one issue. On count 4, the murder of JJ Vallow. It says on the indictment that he died, that he was killed between September 8th and 9th of 2019. The state did not prove that. Their argument, that's when Tylee died. Their argument was that he died September 22nd and 23rd. So the date is wrong in the indictment. John Pryor is saying because they got it wrong, they didn't prove it, that count should be dismissed. So we wait. At 2:30, court comes back in session. The state will argue if they will say, will argue their point, and the defense will have a chance to respond. So, yeah, many of you are saying that it might get dropped because of a typo. We don't know. We don't know what they'll argue. Larry Woodcock just spoke with the media a couple of minutes ago. This only affects the one charge, not all of them, just the one charge. And it'll be very fascinating to see what happens. So at 2:30, be sure to tune in. We'll have live coverage. You can hear what the judge rules, and we'll see what happens. And what we do know is that the defense will be prepared to start come Monday, unless everything changes this afternoon. So we'll have the latest. Stay with us. You can go read all the updates on eastidahonews.com, and we'll keep you posted.
My mind is just blown. Just blown, man. Oh, like QB said, I mean, he may have a saving grace with it being the judge that found it and not Pryor, because if Pryor would have it, then it would totally be, he would have a complete argument. I don't know. I don't know. He was absolutely broken. I wish that they would have had the microphones on. I couldn't hear anything. Just sad. Sad. QB, do you want me to drop the link again for you? Hold on. I sent it in Discord, QB, if you can grab it. Let me go over here to could share this screen. Share. So that we'll have, I mean, I know that I wanted to resume day 23 where we ended, because we are behind. This is supposed to be a speed watch, but I just, ooh, hey, QB. I just really wanted to, like, I wasn't going to be able to stream that and then not know what's going on with this, because this is a huge deal. Hey, QB.
Hey, I couldn't figure out which one was me. Which me was me.
Oh, it's you. It's you.
It's me. It's me. Yeah. So, okay. So here's why this matters. If the date was a huge source of contention, okay, which it really wasn't. It kind of was, but it wasn't. If that makes sense.
Yeah.
So, if the date being wrong, is prejudicial to Chad Daybell, then that becomes a bigger issue. The fact that Pryor didn't bring it up and that the judge brought it up helps. But on the same token, the fact that they were adamant, I mean, they went all around and who was there, and then Alex took him up the stairs and what was the date, and da 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 da, and yada yada yada. And so they were adamant that that date was a 22nd, 23rd.
Yeah.
And so then Pryor's motion is correct because they didn't prove that. They
Yeah,
didn't
right.
prove that it was the 8th and the 9th. And so that's a problem. Then on the flip side of that, again, because Pryor, or okay, I'll say it that way, because Pryor didn't bring it up, and it was the judge that brought it up, it makes me think that the judge is like, hey, by the way, just want to let y'all know that this ain't right. We probably need to change it. I think the fact that it was initially right should bear some weight.
Yeah.
But I don't know that it does. I mean, I feel like it should, but I don't know legally if it does or not. Y'all, I got enough Chinese food for like 6 people. I'm hungry.
Did you get some General Tso?
I did. It's my favorite. I got General Tso's. Y'all are gonna laugh at me. I got General Tso's. I got hot and sour stew. I got some spring rolls, and I got some Singapore My Fun. I'll eat on it
What?
for 3 or 4 days. Singapore My Fun.
I don't know what that is.
It is basically a curried rice noodle with chicken, pork, and steak, chicken, pork, and shrimp, chicken, pork, and something. I don't know, but I'm gonna dive into my hot and sour soup to start with.
I'll tell you right now, I'm the weird one that I'm like the 5-year-old that eats at the Chinese buffet who goes for the
You get the chicken.
I go for the gas station pizza at the Chinese buffet.
Man, that's not okay.
Well, I'm just not a big Chinese food person.
Oh, I love Chinese.
I don't mind the chicken, but the soups and the rices and nah.
Behind tacos, Chinese is my second favorite. Chinese and Italian would probably be. But this is a new place I'm trying. The thing I like about them is that you can pick your hotness.
Oh, yeah.
I like that.
Buffalo Wild Wings.
Yeah, so you can it's mild, medium, Y'all, it is gonna rain again. I cannot, y'all. But my new jam is hot and sour soup. This mess is good. This mess is good.
I want some. My nephew, he always calls it B Dubs. I want some B Dubs
B
now.
Dubs. I never eat there.
I
They think a
love.
lot of their wings. They have really good wings, but they think a lot of them. But
Yeah, I know.
we have
They're
one right around the corner. What time is it? Is it time for them to be back yet? God bless.
expensive. You know what, Hardee's? They used to not be outrageous. I don't know what
They're
happened. It's like when they like
crazy.
came back out and like revamped, they just like was like,
They're
you know
crazy.
what? We think we should double our prices.
They got. I'll tell you what though.
Kind of like Arby's, man. They're just they're the bougie fast food.
I'll tell you what though. Hardee's has got this burger. I can't remember what it's called. I don't go there very often.
Frisco?
No.
I love a Frisco.
It's like a barbecue bacon double, put some onion rings on it kind of burger.
Oh, they have
It's
something like
good.
that at Wendy's that's the bomb.
See,
It's
I
like
hadn't tried it at Wendy's.
It's the pretzel baconator. Oh my god, it's a pretzel bun, and they've got like onion straws and some kind of yummy like dressing
Does it have
on
a
it.
barbecue sauce on there? Because I hadn't tried it. Everybody talks about that baconator on the pizza, on the pretzel bun.
I don't know if it's barbecue or what, but they've got a really good sauce on it.
Oh no, that pretzel bun can be hard sometimes.
I love it. Love it.
But y'all, I might have found my new Chinese place. Damn.
We were going to get Culver's last night for dinner, but we ended up switching and getting Arby's instead, and it was yummy. But
Do y'all have the Wawa up there?
no,
Okay. It's just a Pennsylvania thing, I guess. It's not just a northern thing. Not doxing you.
thank you.
You're welcome. But I love the Wawa, and they're bringing one here. It'll be next year, but they're bringing one here, and they're bringing. Do y'all have sheets?
Have what?
Sheets.
No.
What do y'all have? God bless.
We have rallies.
No, I mean for gas stations, like gas stations with food. Do you have any gas stations that like have like a hot bar or?
Oh yeah, we do, but I ain't gonna name them because then I will dox myself.
Don't dox yourself. Okay, so Wawa and Sheets is like that, but like on crack.
I'm cross stitching again.
They're bringing.
How's it going? I'll have this one done. It won't be well. I mean, maybe a few more days, but
how are you getting adjusted to it?
Yeah, I am. It's not as bad as it was.
Kayleen, but sorry, Kayleen
Oh,
said.
hey, Kayleen.
Said my love language. Buc-ee's, there ain't no place like Buc-ee's, man. No place. Not a Wawa's, not a Sheets. Ain't no place like Buc-ee's. And they just opened one about an hour from me. And it's been all I could do not to drive down there and go see it. But ain't no place like a Buc-ee's. Ain't no place like a Buc-ee's. Lord, I sat down here with all this hot stuff and I ain't got nothing to drink. What the what? What's wrong with me?
All right, youngins, it's 4:28. A couple
Let's
more
go.
minutes. I got like ants in my pants, man.
Well, it sounds like they're going to argue it. That might be just what I needed to just knock my nose out. Let me tell you what, they got it perfect. They got it perfect. Like, it is just enough to have the little tasty taste. But can I put that in there? Y'all, I've been hiding my Diet Dr. Pepper. Y'all don't tell nobody.
Mm.
Y'all don't tell nobody.
So your kids will steal them?
So they won't.
I know, but I'm saying so they do. They will do that
Yes.
though.
And try to act like they don't.
Mm.
Try to try to act like they don't. I call BS because the minute I stop having them all in there, do you need me to pick you up anything? You need any Diet Dr. Peppers? No, homie, I don't.
Mm-hmm. Unless you got the last one. Then I do. My nerves are on edge, man. I'm struggling over here.
Hi.
Hi.
My alarm went off. Sorry.
Oh, I didn't hear it.
I'm trying to stop drinking so many sodas anyway, so but yeah, I hit them.
Well, we usually just buy like Diet Mountain Dew, but I don't drink it very often. I might have a few a week. Like, and by a few, I mean literally like 3 to 5 a week. And I know that might sound like a lot to some, but I might have like
You
2
did-
in one day, and then I can go days and days.
They're
Oop, they're
coming.
back.
They're coming. And also, hey Kayleen,
All right, good
sorry.
afternoon. We are back on the record on case CR 2221-1623, State of Idaho versus Chad Guy Daybell. We took a recess after the court heard argument on the defense motion for judgment of acquittal under Criminal Rule 29. I indicated an issue with count 4 and permitted additional time for the state. Before going into more argument on count 4, I have taken the time to prepare a ruling on the other counts on the motion. And I think for efficiency purposes would go through the ruling I've got as it relates to the other counts in the case, and then reserve some additional time to further discuss where things will stand with the count 4 of the amended indictment. So proceeding in that manner, the court would first note that the motion under Rule 29 for a judgment of acquittal, as I mentioned before, is for the court to consider whether there's evidence insufficient to sustain a conviction. There's some case law that goes further into the standard of review on that, or the burden of proof the court looks at in determining this motion. Some of it cited appropriately by the state. I'll note from the case State versus Taylor, 157, Idaho 186, talks about, says under ICR 29, the district court may set aside a jury verdict or enter a judgment of acquittal if the evidence is insufficient to sustain a conviction. The 14th Amendment of the United States Constitution guarantees the right to due process, and the U.S. Supreme Court has held that as part of that due process, quote, no person shall be made to suffer the onus of a criminal conviction except upon sufficient proof defined as evidence necessary to convince a trier of fact beyond a reasonable doubt of the existence of every element of the offense. And there's some internal cites there. Going on, the case states the relevant inquiry is not whether this court would find the defendant to be guilty beyond a reasonable doubt, but whether, quote, after viewing the evidence in the light most favorable to the prosecution, any rational trier of fact could have found the essential elements of the crime beyond a reasonable doubt. And that cites a case, State versus Adamanchik, 152 Idaho 460. And then finally, thus, the only inquiry for this court is whether there is substantial evidence upon which a reasonable jury could have found that the state met its burden of proving the essential elements of the crimes charged beyond a reasonable doubt. Substantial evidence is more than a scintilla of proof.
but less than a preponderance. In short, it is relevant evidence which a reasonable mind might accept to support a conclusion. So finally, the court is required to consider the evidence in the light most favorable to the state, but will not substitute its judgment for that of the jury on witness credibility, weight of the evidence, or reasonable inferences to be drawn from the evidence. So that's the standard of review the court considers in ruling on a motion under Criminal Rule 29. Starting then with the counts that I am prepared to rule on count one, having considered the arguments of the defense and the state, the court does find that the state has presented sufficient evidence that would permit a reasonable trier of fact to find the essential elements of the crime beyond a reasonable doubt. And that's on the conspiracy to commit first-degree murder and grand theft by deception involving victim Tylee Ryan. The court notes that on identification of the defendant, which is one of the elements, he was identified by several witnesses, including Detective Ray Hermosillo, Ron Arnold, Detective Kaya Kamanu, that in terms of the dates listed in count one, surveillance from Officer Joe Powell helped establish those in the testimony of the other witnesses I mentioned, that this occurred in the county of Madison, state of Idaho. There were locations testified to by Officers Joe Powell, Colin Nesbitt, that the victim Tylee Ryan was identified in that count by, among others, Colby Ryan. Looking at the overt acts that the state went through and alleged 1 through 7, the overt acts evidence of those came in sufficient to withstand a Rule 29 acquittal from Detective Nathan Duncan and Zulema Pastenis testified to some of this. Also on the second overt act, Michael Douglas, Mark Sari, Chuck Consitis, also Chuck Consitis on the third overt act. Detective Nathan Duncan testified on issues related in the fourth overt act. On the fifth overt act, Nicholas Balance and Nicole Heidemann testified about that. On the sixth overt act, Mark Sari, Chuck Consitis testified regarding that, and Mark Sari also on the seventh element. The court then, in considering that standard on a Rule 29, finds there's sufficient evidence, and so the motion's denied and the jury will be allowed to consider count one. Count two is the first-degree murder charge of Tylee Ryan, and evidence was provided identifying the defendant by witness Ron Arnold. There was date indications of when this occurred established by Rick Wright, among other witnesses. And the plan that is referenced in there was also testified to by Rick Wright and Nick Edwards. There was also information about identifying Tylee Ryan, identifying her as a person by Colby Ryan, Tara Martinez, Dr. Garth Warren. And looking overall at the evidence submitted, the court does find the state's met its burden to withstand a Rule 29 motion, and count two, the judgment of acquittal motion is denied. Moving next to count three, conspiracy to commit first-degree murder of JJ Vallow. The court notes there was sufficient testimony and evidence presented to also deny the motion for judgment of acquittal on this count three. The identification of the victim established by witnesses including Kay Woodcock and Brandon Boudreau, that the overt acts again were testified to by witnesses including Zulema Pastenis, David Gibb, Ashlyn Rand, David Warwick, Melanie Gibb, Colby Ryan, Ray Woodcock, Mark Sari, all testified among those seven, actually six overt acts that are alleged there. The court does find sufficient evidence in testimony and admitted exhibits to allow the state to move forward and seek jury deliberation on that count. I'll skip over count 4, as I mentioned. On count 5, this is the conspiracy to commit first-degree murder of Tammy Daybell. Also, the court denies the motion for judgment of acquittal under Rule 29. In that particular count, the identification of the victim was established by Samantha Gwilliam and others. The defendant was identified relating to that count by testimony from Craig Huff, Zulema Pastenes, Colby Ryan. Looking at the overt acts established, there were 12 in that count, and the court notes that there was, again, identification of the victim, Tammy Daybell, by Samantha Gwilliam. On count 1, some evidence came in through testimony of Jason Gwilliam, Ian Pulowski. Count 2, Ashlyn Rand and Chuck Consitis testified about the overt act there. Count 3, Nick Edwards. Count 4, Nicole Heidemann. Count 5, Nick Balance. Count 6, Zulema and Nick Edwards established some testimony to allow those overt acts to be considered. Count 7 had some testimony from Angela Yancey. Count 8, Coulter Cannon. Count 9, Nick Edwards. Count 10, Rick Wright. Rick Wright also on count 11 and 12. And also Nick Balance testified about overt acts in 11 and 12 also. And considering the standard I announced at the beginning of the ruling, court does find that there's sufficient evidence the state's presented to deny the motion on that count 6. Count 7 is the insurance fraud count. The defendant was identified as to that particular count, among other witnesses, by Craig Huff, and Angela Yancey established the date range that's in the count. Also Taylor Ballard, and the state did provide sufficient evidence regarding the allegations of the insurance fraud count to withstand the Rule 29 judgment of acquittal. Similarly, on count 9 of insurance fraud, again, the defendant was identified by Taylor Ballard. The date range was established by Angela Yancey, who testified also that occurred in Madison County. Prior count also, the venue of Madison County was established. And then also Angela Yancey established evidence relating to the allegation of a fraudulent claim as set forth in count 9. So upon considering the evidence presented in the state's case in chief on those counts, the court is denying the motion for judgment of acquittal. And at this time, the court is going to permit some additional argument from the state as it relates to count 4, the first degree murder count, as it relates to JJ Vallow and the issue the court brought up. So Ms. Beatty, are you prepared to argue that?
I am, Your Honor. Thank you.
I'll hear additional argument on count 4 then from the state, and I'll allow additional rebuttal argument as well from the defense.
Thank you, Your Honor. Your Honor, in looking at the case law and the relevant rules and statutes, the state really has 3 options for the court at this point. The first, and I'll talk about each of them in a little more depth, but the first option would be, because count 4 of the amended indictment did not fall within the scope of the court's December 8th, 2023 order to amend, and we'll get to that in a moment, the court can simply correct it under Idaho Criminal Rule 36 so that it conforms with what count 4 should be, which would be count 4 as set forth in the original indictment. And I'll discuss that more in a moment. Second, the court could accept that we do have a variance here and either instruct the jury on a variance between the jury instructions and evidence that they've heard, or the court under State versus Jones, which we'll also discuss in a moment, the court could address that variance by simply putting in September of 2019 in the count 4 jury instruction, which is very similar to what the court in Jones did, as we'll discuss in a moment. Third and finally, the court would be within its discretion to reopen the case to allow the state to correct the indictment if the court does find that it needs to be formally amended. So as to the first option, The state did not move to, and the court never granted a motion for the state to amend the indictment as to the date or as to the date within count 4 or as to anything about count 4. Under Idaho Code 19-1420, the state can only amend without leave of the court prior to entry of plea. Under Idaho Criminal Rule 7E, the court grants the state leave before amending a charging document. In this case, the state made a motion to amend the indictment on November 23rd, 2023 in 3 very specific ways. The first was to modify the subsection referred to in counts 1 and counts 3 from Idaho Code section 182403 sub 4 sub A to section 182403 sub 2 sub A. The second change requested by the court was to modify the language in counts 2, 3, and 5 from, quote, the defendants, Chad Guy Daybell, Lori Noreen Vallow, and Alex Cox, unquote, to, quote, the defendants, Chad Guy Daybell, Lori Noreen Vallow, and or Alex Cox, unquote. Finally, the state requested that leave to amend the indictment to modify the language in Overt Act 10 under count 5 from, quote, month, unquote, to, quote, months, unquote. Importantly, Your Honor, nowhere in the state's motion did the state ever seek leave to amend any portion of count 4. On December 8th of 2023, the court granted the state's motion. The court's order states, quote, for the reasons stated on the record, the court will grant the state's motion. The amended indictment is ordered to be filed in the case, unquote. Subsequently, of course, the state did file an amended indictment, but in that indictment, it does appear that the date within count 4, the first-degree murder charge of JJ Vallow, was inadvertently changed to the same date as the murder of Tylee Ryan. The state would note that the initial indictment was filed in this case on May 25th of 2021, and in that indictment, JJ Vallow's death dates were properly set forth as the 22nd and 23rd of September of 2019. Just 2 days after that, counsel for the defendant filed his notice of appearance in the case. This matters in the court's analysis because it goes to prejudice and it goes to notice where we had an indictment with the correct dates for 2.5 years, during which the entirety of that time, counsel and the defendant were aware of that date range. And we'll discuss that in a moment as well. Ultimately, because this is a clerical error that needs correcting and count 4 was never properly, was just simply not amended in any legal sense because the state is not able to do that without leave of the court, and the court did not grant the state leave to do that. The court could utilize Rule 36 to make that amendment. Certainly, this would require a jury instruction of some type, and the state does not have a proposed jury instruction because the jury was read the indictment earlier in this case, of course, but that would be an option that would be available to the court. The second option would be for the court to accept that this is a variance, which does happen and is accounted for in the case law. And frankly, Your Honor, it's not a proper subject for a motion for acquittal. In fact, a date is not an element of a crime. And I know that that sounds counterintuitive, where our ICG standard jury instructions have the defendant's name, they have the date, they have venue, but venue and date are not elements of, they're simply not a factual element of a crime. And an Idaho Supreme Court's case, State versus Jones, dealt with that very issue. In State versus Jones, a defendant appealed from a lewd and lascivious conduct conviction, and he argued on appeal that the information, the charging document in that case, did not sufficiently apprise him of the nature of the charges against him. Specifically, the Jones defendant argued that the charging document did not identify the time, location, or information that he needed to prepare a defense. In that case, in that charging document, there was a range of numerous years where these crimes could have been committed. The Jones court explained that generally, a defendant cannot be prejudiced, quote, by the absence of specific details in the information when those details are already known to the defendant or are provided to him by means other than the information, unquote. And that pinpoint citation is 140 Idaho at 47. The court specifically in Jones rejected an argument about a lack of specific time set forth in the indictment. And I'll just read straight out of the case. Jones's next argument that the information was insufficient for failure to allege a specific time of the offenses is also without merit. Under Idaho Code 19-14-14, the precise time at which the offense was committed need not be stated in the indictment, but it may be alleged to have been committed at any time before the finding thereof, except where the time is a material ingredient in the offense. Time is not a material element of the crime of lewd and lascivious conduct with a minor. The Idaho Supreme Court, and I'm still reading from the case here, has stated that, quote, any other rule would too often preclude prosecutions in this type of cases where victims are minors and where crimes are not discoverable until sometime after their commission, unquote. So I think what we have here is the court explaining that these timeframes, there are other factors that can be taken into account here. And so while it's not directly on point because we're talking about a range of many years, and here we're talking about a variance in days, I think it's important to note that the court clearly didn't see a very specific tight time frame as an element of the offense in Jones. So the Jones court went on to explain that what we're really talking about here is variance. And diverting from Jones for just a moment, Jones also discussed the Windsor case, which the pinpoint citation for that is 110 Idaho 410. And in the Windsor case, the court really set forth an explanation of what variance is and the standard for variance. Quote, the true inquiry is not whether there has been a variance in proof, but whether there has been such a variance as to, quote, affect the substantial rights, unquote, of the accused. The general rule that allegations and proof must correspond is based upon the obvious requirements that the accused shall be definitely informed as to the charges against him, so that he may be enabled to present his defense and not be taken by surprise by the evidence offered at the trial, and that he may be protected against another prosecution for the same offense, unquote. And again, the Jones court, after citing from Windsor, also discussed how variance between the information and evidence presented at trial or between the information and the jury instructions only require reversal of a conviction where the defendant was, quote, deprived of fair notice of the charge against which he must defend or was left open to the risk of double jeopardy, unquote.
I do have a question about variance.
Yes.
Because I've looked at some of the cases that do discuss variance, including the one I previously cited, State versus Anderson, 172 Idaho 133. And in this instance, I think looking at the context of how variance occurs, I guess the point I struggle with here is it appears to me variance typically comes up when for whatever reason, jury instructions don't match the charging documents. And there is a presumption that the jury instructions should match the charging documents. And that's in a case, State versus Bernal, 164 Idaho 190. Here, essentially, what the state would be requesting is that we don't have a variance yet because the jury hasn't been instructed on something that varies from the charging document, but you're suggesting I permit or sanction a variance and allow the variance to come in to essentially cure an issue raised on a Rule 29. And I see that as very different than any of the other cases. So are you aware of any authority where the court proactively let a variance occur to fix something in order to withstand a motion on acquittal?
And Your Honor, well, a couple things. So first of all, I don't believe that the defendant did raise this specific issue on his Rule 29 motion. I understand the court is considering it at this time. But I do think that I just want to make that clarifying point because I think it goes to prejudice.
And I believe that's totally accurate. It was raised by the court.
Thank you, Your Honor. But I believe in the Jones case itself, the court, Jones, I'll just read from the case. Lastly, Jones argues that the court's instructions to the jury constituted a fatal variance because the court added, quote, on or about, unquote, to the time frame of the offenses alleged in the information. He contends that this broadened the basis upon which Jones may be convicted. We disagree. The slight expansion of the time frame does not allow the jury to find Jones guilty of a different offense than that alleged in the information. Jones has identified no fatal variances between the information and the evidence or jury instructions.
Okay, I appreciate your response to that.
Of course.
question.
Thank you, Your Honor. So that would be the state's, and I understand that, I certainly understand the complexities that this course of action presents to the state. But there is that third option as well, which is obviously a clerical mistake was made here. It's inconsistent with the initial indictment. It was not it was not a proper legal amendment. We're really talking about a clerical issue here. And I think that when courts look at reopening cases, that's something the court can do for situations such as this. So if the court declines to proceed with correcting the indictment on the basis that it was never properly amended, or if the court is unwilling to proceed with a variance, the court can reopen the case to address this issue, at which point the state would then amend it before resting, which would bring the state into compliance with Rule 7E. That would put the amendment in compliance with the rules and relevant statutes. So in addressing the court's ability to take that course of action, I think State versus Cutler is a good case for that. In that case, the Idaho Supreme Court stated, a justice presiding in a criminal case not only has the responsibility of protecting the rights of one accused of crime, but also an equal responsibility to the people of the state, to the end that justice is not thwarted by mistake or inadvertence. The presiding justice under the circumstances of this case are well within his rights and his discretionary powers of trial procedure in permitting the state to reopen and present further evidence after the respondent's motion for a directed verdict of not guilty had been made, unquote. And I think that's very applicable to this case, Your Honor. I also think that another case that the court could look to would be State versus Huggins, 103 Idaho 422. In that case, the court noted that some reasonable excuse, such as oversight, inability to produce, or ignorance of the existence of evidence, must be established by the moving party. And Your Honor, we're all kind of falling on our sword here. This was clearly an oversight. We're talking about a clerical error in a subsequent document that was not in the initial document. This is exactly the type of mistake or inadvertence that the court could reopen this case for. And I think defense counsel argued earlier that it would be unfair to do that after the defense made a Rule 29 motion. I'm not aware of any legal authority that supports the assertion that making an oral Rule 29 motion on totally unrelated grounds tolls the state from doing that. But certainly there might be something out there that we're not aware of. But I do think that under this case law, if the court felt that a formal amendment was necessary, the court could reopen the case. Thank you, Your Honor.
All right, thank you for the citations and the well-argued points there, Ms. Beatty. Mr. Pryor, any response from the defense on this?
Judge, I'm going to work in reverse. And as far as reopening the case, the authority to reopen a case is almost exclusively applies to evidence, Judge. It does not apply to amending an indictment, information, or complaint. If the court recalls, I don't believe I objected to the original amendment to the indictment when we did that back November or December. The court read the indictment, went over it in detail with the state, and the state acknowledged that this is the indictment that they intended to go forward on. And from that time forward, that's the information that I relied on. And any change at this point after the state has rested is going to create a substantial due process argument for Mr. Daybell. In addition, it's going to affect the substantial rights of Mr. Daybell as well. The difficulty is this, Judge, is we have a very specific statute, 1914-20. 1914-20 says in pertinent part that the state may move after the defendant has pled guilty to a charge. Now he pled guilty, not guilty, and he did enter a plea of not guilty, and the state properly came forward and asked the court permission to amend the indictment. They then amended the indictment. And since approximately December of 2023, that indictment has remained in place in full force and effect. Now, they have that right to amend the indictment under 1914-20. But then we get to a very specific, a very direct rule, and that's Rule 7E. And Rule 7E says in pertinent part, Judge, that the court may permit amendment of a complaint, information, indictment at any time before the prosecution rests. To my recollection in reading the statute on short notice, Judge, I never saw the words variance. I never saw, correct an error. I never saw anything to suggest that they have any right to do any of this. And there's a State versus O'Neill, Judge. I think it's 118 Idaho 244 that talks about Idaho code and the statute 1914-20. But Judge, the specificity of 7E doesn't say the court has the authority to go back and allow them to reopen. It doesn't say they have the authority to go back and create a variance. It doesn't say they have a right to go back and make a correction. What it does say is they may and they have to make any amendments or corrections prior to resting their case. There's nothing else that says, well, we got a little bit of wiggle room here and let's let them change things after they rest their case. And 4 lawyers had a chance to look at this indictment. 4 lawyers have had over a year to analyze this. And then after they rest their case and decide that the court picks up on the fact, and Judge, I mentioned to the court that there were elements. I wasn't going to key the prosecutor off that they had a problem. And if the court didn't catch it and there was subsequently a problem, someone else would have caught it and would have corrected it in the future. But they don't get to correct it now. They don't have any authority to say that. The cases they cite talk about other issues that have nothing to do with having the ability to change an indictment as I am preparing to present my case to the jury in this case on a capital murder case. They've lost their chance. They don't get to go back. Judge, I'm asking the court to dismiss the charge.
All right. Looking back over a rule here, I have an additional question perhaps from Ms. Beatty. I'm looking at Criminal Rule 36 about clerical mistakes. Is it the state's contention that an indictment would be included among the documents that may be corrected for a clerical mistake? Because it does specify, it doesn't say anything can be.
It doesn't, Your Honor. And I think we take that position just based on the language in the rule that says, quote, or other part of the record, unquote. However, I will be candid with the court. I did not specifically check Westlaw to see. That was not one of my, I didn't do a deep dive into that. But I think that where we're talking about the criminal rules, judgments and orders can be amended, and any other part of the record. That's a very broad, expansive language. The record clearly would contain the criminal record in a case. I do think that that rule in its plain language could be applied to encompass an indictment.
And Judge, could I respond, please?
Yes, you may.
Judge, Rule 7 specifically says they're not allowed to change it after it rests. It's specific. And regardless of what Rule 36 says about other issues, and it's vague, we have a very specific rule being Rule 7. And Rule 7 makes it very clear. They don't get to amend. Regardless, they don't get to amend. It's a very specific rule that references this very issue. 36 is vague. This rule is specific.
Your Honor, may I briefly respond to that?
And that'll be the end of argument, but you may.
Thank you, Your Honor. The state would just reiterate that there is a process for making these substantive amendments, and there was not a substantive amendment made in this case because it did not fall within the scope of the order. And so we're not asking the court to make a substantive amendment when Mr. Pryor is citing Rule 7E or 7F. We're asking the court to correct what is clearly a clerical mistake within the scope of the court's order, which is how I would respond to his citation of Rule 7.
Okay. So essentially arguing you moved to amend the initial indictment and the court granted the motion for specific grounds. And on February 20th of 2024, the amended indictment was filed, which has changes. And those were all drafted by the state. And your argument is that amongst the changes you put in the new amended indictment were clerical errors that should be corrected because they were not intended to be or should not have actually been amended. Is that essentially the argument?
That's correct. And I would take it one step further and say that as a matter of law, count 4 was not amended because we did not have leave from the court.
And Judge, I'd like to respond.
Okay, I will allow another response because I'm just considering all this. Mr. Pryor, go ahead.
Judge,
they made the amendment to the date. They made the change to the date. They had an opportunity to review this. And then this indictment gets read to the jury and once again published for all to hear, including the 4 lawyers that are sitting across from me. And at no time do they catch that potentially there's an issue. And at this point, Judge, the rule is very clear. They have an indictment. They made the allegations. They're stuck with their indictment.
All right, counsel, let me take a brief recess, discuss this with my staff attorney, do some quick research and get prepared to make a ruling as it relates to count 4. I think time is of the essence to determine this issue, so we'll go as quickly as we can to get back on the record. I'll have the marshals advise you when we're ready to make an oral ruling. All right.
Wow. Pryor made a great argument. And the prosecution, I just felt like, was like, well, here's this option, here's this option, here's this option, all of which could cover our butts. But then when Pryor read that 70 or whatever rule, literally says you can make amendments to the indictment until the state rests their case. Boom. QB, where'd you go, ma'am? Bye, Margaret. Be safe. Hope mom has a great doctor's appointment. Hope it's nothing major. I'm physically ill. Ugh.
Hey,
Hey,
I had a malfunction. I'm back.
yeah, Miss King. He said that, and then he said when he said it the second time, right before they went to break just now, I was like, "Well, you heard him read it too, Pryor. You didn't catch it either, sir."
No, I think based on what got said today, I think he saw it. I think he saw it and he didn't bring it up.
Well, I mean,
because he said he goes, it's not my job to bring it to the court's attention. And if the court wouldn't have brought it up, it probably would have been brought up by someone else.
Yeah.
Yeah, he knew. He may not have known from the get-go because it wouldn't be from let's see, February. Yeah. I don't know what the law is regarding. Yeah, he doesn't have to, Morgana. I don't know what the law is regarding an indictment being wrong before the trial starts. I don't know if he has any obligation to bring that up. I don't know. I don't think that he does. But QB,
are you good to chat for a few minutes with
yeah.
I need to go wee wee. I need to go wee wee.
Go wee wee. Wee wee.
Wee wee.
Wee wee.
Okay, I'll
yes,
be right back.
I'll
be right back.
Okay. Y'all. I was trying to look. If I fall out, I can put myself back. I was trying to look at what the indictments were for, because what is the other one for JJ? Is it like abuse of a corpse, or I couldn't remember what it was. Yeah, I think he knew, Kayleen. I mean, he definitely knew. He definitely knew when they started, based on what he said. But he's not wrong. They amended and here's the thing. Their argument is that there was no amendment to count 4 that they requested, or that the court requested from them, or whichever way it happened. So who the heck went in there and changed the daggone date? Why did anything get changed at all? Why did anybody touch it? if there was nothing to be amended? I don't understand. Y'all hang on. Trying to see what the yeah, it may have been the theft, the Social Security money. I know they got him on Tylee's insurance. No, Tammy's insurance. I'm looking for the full indictment. Here it is. I found it. I need my other glasses. Okay. All right. One is it was count 3, I think. Count 3. Blah blah blah. Yeah, it was the theft. Yeah. Sorry, I'm trying to speed read. Yeah, it's the theft. Okay. It's the theft. So that's really not enough. In the elevator, what happened? Okay, he's discussing, or no, he's discussing with the staff attorney, and he'll come back with a ruling. But basically, what happened was Pryor argued a good argument. The sad part is the original indictment. Why did they mess with count 4 if okay, wait a minute, that's count 6. That I went too far. Count 5, count
Back.
4. Hey. I'm reading the indictment. So the other indictment, the count 3 that goes to JJ, also, by the way, that baby made my whole entire year.
Do what?
I said that baby made my whole entire year saying hi, Kiwi.
Oh.
Hi. I love you. She's my favorite person ever. So count 3 is the other indictment that applies just to JJ. And I was looking back to find out what it was because I couldn't believe. Yeah, I agree with you, Mickey Jor. I think he's going to have to.
I mean, the only way I think that he won't would be if he can somehow find some kind of legal basis based on the 3 options that the prosecution gave him. But, and I don't know. I mean, I'm sure that Judge Boyce is going to go back and look at the rule that Pryor quoted, but maybe there's an out to that, and Pryor just didn't read it. He just left that part out, I don't know.
I don't see. I think the fact that he's going back, I think the fact that he's going back to talk to the staff attorney and everything else is like he's looking for anything. Please give me something so that I don't have to drop this charge.
Right. Yeah, absolutely.
But I don't know how they can't. What I was saying I don't know if you heard it or not, but what I don't understand is her argument was that when they made the amendment to the indictment, okay, if they when they made the amendment to the indictment, they're saying that there was nothing in count 4 that needed to be amended, so it shouldn't count. Okay, because it doesn't fall under, they didn't get leave from the judge to change anything in count 4 because there was nothing the court was asking to be changed. Okay, great argument, except for the fact that y'all freaking changed something in count 4, which was the date. Why did anybody go in there and mess with it?
I don't know. I don't know. I I have no
Why
idea.
did anybody? I mean, did somebody go in there and go, "Oh, look, they got the date wrong," and then they changed it to the wrong date? I mean, like, I don't understand. And the way Wixom is hanging his head is probably him.
Well, I mean, he was hanging his head awful hard, and that's why I said
But and Pryor ain't wrong. 4 attorneys. Y'all had 4 attorneys reading over this mess. And law clerks and everything else. Pryor's over there by himself with, deputized Daybell. I mean, I am. Jaylene said it was me. I make typos all the time. Girl, you best go back and check them briefs. I just don't know how. I didn't hear any argument from her. I was almost going to give her the whole we didn't have leave to change Amendment 4, and I don't know that he couldn't possibly rule in their favor for that, but I don't know how he can. And I think they should be. I don't mean no. I absolutely mean harm. Somebody needs to be sanctioned. Somebody needs to be in trouble.
yes, absolutely, 100%.
Not just losing their job, not just packing their desk, not just turning in their keys and their key card. I'm talking money. Somebody needs to pay some money. All right, Kaylee, then that's fair. Don't worry about it then.
I'll tell you what, I bet you anything that that every one of them over there on that prosecution team's changing their briefs too.
Yeah, they probably are.
Can you imagine how embarrassed they must be?
This is the second time. It's not the same, but it's still a mistake. It's still a mistake. I mean, I got glasses on glasses. If y'all's glasses don't work, go to $1.25 tree and get some more glasses.
Dang, I do it all the time, right?
Facts. Same.
Don't be embarrassed about it. Don't worry
I take
about it.
pictures with them. So do you. You on the whole interwebs with them on.
Yeah.
I was gonna send you
They
that.
need to do something. Oh
Somebody
my
needs to
God.
pay. Somebody needs to pay. And I'm not just talking their job. I'm talking, I want butt cheeks. I want something.
Well,
Tore
I
up.
mean, if they're going to be if they're going to be paying money, I want them to lose their job too.
Well, yeah, no, I'm saying they should lose their job and then be sanctioned or be brought in front of a judiciary committee with the Bar Association or something.
I don't know.
I'm
It does take attention to detail. You're right, Miss King. Like QB said earlier, you should have 14 sets of eyeballs looking at it. When you look at that kind of paperwork over and over and over and over and over, you just get to the point where you just
Yep.
like eyeball things, right?
You know
You
what
just
we
like,
do?
okay, that looks good. That looks good. This is good. The date's on that side. This one's good. But it's like when you walk through your house. Okay, here's a good for instance, you guys. It is May. I still have my Christmas tree up. I've had my Christmas tree up for 5 years and ain't never took it down. Do you know what? When I walk by that tree every single day, 15 times a day, I don't even notice it's there. Why? Because I look at it all the time.
Yep. Yep. And so here's what we do. I say we as in me and the mouse in my pocket and a couple other people that I've worked with in editing and stuff like that. When you've done a document over and over and over and over again, first of all, you hand it off to someone else. Second thing you do is you read it out loud.
Yeah.
Because then your brain will automatically skip stuff. You read it out loud, your brain can't skip it because you have to form the words. Third thing is you read it backwards. Okay. because then your mind can't predict what's coming. Okay. So when you're reading it backwards, you're not checking for sentence structure, you're checking for corrections or misspelled words, or I don't know, dates that are wrong.
Well, I mean, if you're going to
Um,
look at anything, if you're going to double, triple, quadruple check anything, it's going to be dates and names.
yeah, yeah. But see, and the night before you rest your case, you dot all your I's, you cross all your T's, you cross. I don't know what else there is to do, but you do it. And I don't mean read backwards. I mean like take the sentence, like your sentence right there, and say backwards. Read can't I. That way you're slow and you're intentional and you're reading the words and checking each word. Your brain will automatically skip. They've shown it. If you've ever
Mhm.
seen those puzzles where like the first and the last letter
Yeah,
are
or
the
that
right
thing
letter,
like if
but the
you can
middle,
read this, then you must be a military
right,
daughter, or you know
right,
what I mean?
yeah. So, but
Foxtrot,
most
blah 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 blah
people,
blah.
yeah, but not that, not that. No, what I'm talking about is that when they show like the first and the last letter of the word are correct, but the middle ones are not, and they
Mm,
do a whole sentence like that, your
yeah,
brain will automatically pick the word that fits the length and the two first and last word or letters.
yeah,
And
yeah.
it'll automatically do it. And so you can read a sentence like that is complete garble, but your brain will fill in the blanks. And yeah, this is
Well, you know that there is a class that one of their law school classes has to be about,
how not to jack up a whole entire case. Yeah,
well, about how important it is to
numerous
you know,
cases.
God.
Numerous cases. And
And it's not like it's just on some random piece of paper, right?
no,
A
no.
report
It's
it's
on the
on the
indictment.
freaking indictment.
It's on the indictment. It was so serious that look, the lawyer went on and did like a little blurb on Twitter and said, "I'm not going to discuss this right now because I ain't got time," and then turned around and went live on the YouTube.
Yeah, I saw when you sent it to me, but I couldn't open it because I'd already started this live stream. And so when I clicked on the thing, I was like, "Oh, what is it?" And it
Kayleen,
showed him
yeah,
in his car. I think he was in his car.
yeah. He just said that basically what we've been talking about, that this is the problem and these are the options. And basically the three options that he said are what she said. Um and then he also said, to throw the whole thing in the trash, that they could throw the whole thing in the trash and have to start over.
And see, that's kind of what I wish would happen because
It would be
um
better,
I wish that they would because
but he's already gone through and said that he found he's ruling against the Rule 29 motion for all the other parts of the indictment.
uh, um,
They can reach okay, so Mickey Jor, they can recharge him, okay? Um, they can recharge him with the murder, but the fact is one, are they going to get approval because they already spent so much money, going after him the first time, and it was a clerical error that got it thrown out. Two, if they do recharge him, are they able to say that in front of the jury? Okay. Or is it like the prior bad acts and you can't say anything, just that the indictment was thrown out and we're recharging it? Or three, we're recharging it, but it's because we are a whole doofus and we're a whole crap and we messed up. So how does that make the jury? I mean, what does the jury think about the prosecution? Y'all can't even get dates right. How do we know you got all this right? I wouldn't see
right.
them recharge. I think if it gets thrown out and they win everything else, I don't see them recharging them. They might, but I don't see. Mm, I don't know if they'll recharge it. He is back there like, y'all find me something. Somebody find me something. $50,000 to the person that finds me something.
Right.
The only thing. Mm, the only thing that I thought, and I'm not a lawyer, so take it for a grain of salt. The only thing I saw that she got remotely close on was the fact that he did not give them leave to change the indictment count 4.
Mm.
And so if that's the case, could you argue that they went against the ruling and it would be thrown out anyways? Like if he said y'all can change, like they said, oh, we need to amend 1, 2, and 5, and he said, okay, y'all can amend those, but the rest stay the same. And they went in and changed, let's say, the name under count 4, and it was like Charles Vallow or somebody like that. Then they would have to. I mean, they would have to throw that out because he didn't give them permission to change it, and you don't have the authority to do so. But I don't know if they can make that stick. My brain hurts.
My brain and my heart hurts.
Yeah.
It's been a rough day today, man, with
Yeah,
Reed, big,
I'm just done.
Today is done day.
I thought today was a lot in Karen Reed, but it was good for me.
Yeah, it was good. It was good. I just was not expecting this. I mean, nobody was, right?
No, like everybody is just up in arms.
Twitter is upset.
Yeah, they're yeah. I'm just.
Hurry up, Boyce.
Right. He's back there like telling them what is getting the how.
Right, Cherie? She says, what's getting to me
Yeah.
is we're how many months into this trial and this huge mistake is just now caught up? Is just now caught? Hey, Nicole.
Hey, Nicole. Yeah, I think Pryor saw it. The way he was talking, he saw it. He saw it.
QB or Nicole, you're just coming in.
Crap. It's a whole crap.
So
it's a whole crap.
Nicole, we're literally waiting on Judge Boyce to come back and decide whether they're going to dismiss the charges against Chad Daybell for JJ's murder because of a clerical error. That's
also,
basically
hey,
it in a nutshell. Apparently, the prosecution screwed up the indictment. They put the wrong date they put Tylee's date of death for JJ. They screwed it up, and it's just now been caught. The state rested today, and this issue was caught after the state rested. So they may have to throw out JJ's murder charge.
I'm
sorry, I'm wordless right now.
I know, like I am. Yeah.
Nicole, right? I mean, they amended the indictment to make some change to a name or a what even was it? Why they amended it to begin with?
Okay, so there was several things in the other counts that I think the court had an issue with. Like they wanted it to say the defendant, blah blah blah, as opposed to just their name. They wanted
Okay.
basically some clerical things tidied up. And so, but there was nothing in count 4. So they amended it, and somehow or another that date got changed in count 4.
Well, they probably had to amend it in all the counts to get it to say the same across the board on all counts.
No, because they're not the same though. They're different. The dates are different. Because they're
No, I
different.
know, but I'm saying the defendant this, the defendant that, like they might have had to have changed them in all the counts.
Maybe. I don't know, because she said that there was nothing in. Let me look at it. Let me go back and look at it. Stand by. Count 4. No, it says the defendants on that one. It says the defendants on that one. It says the defendants on that one. Maybe that I misheard that. Oh, okay. Count 6 says. Oh wait, no wait. Hold on. Did enter, kill Tamara and Dave. Okay, so they're only charging him with the death of Tammy. I thought they were all being charged with that. Oh, see, in count 7, grand theft.
I'm not sure.
Okay, count set. Wait a minute. Let me go back. Count 7 is the Social Security. So what was count 3? Oh, that was.
Where'd she go? She left. She back. And she's gone again.
And she's back. Yeah, you have to tell me if I bounce out because I'm reading. Try to speed read. I'm trying to figure out why. Okay, count 6. I didn't hear what he said as to I didn't hear what he said as to which one she said that they had to update, because count 1, I could have swore she said something about that the defendants, something that needed to change, that the defendants or something like that, and there was some other verbiage that needed to be changed, but the count 4 didn't have anything in it that needed to be changed. Count 4 on the original indictment says the defendants, Chad Guy Daybell and Lori Noreen Vallow. It doesn't say Alex. Why doesn't it say Alex? Weren't they going after him for for JJ's death?
Yeah, but are you sure it wasn't due to the Social Security fraud?
No, count 4 is the one that's for first degree murder. That's what we're going over. And it says the defendants, Chad Guy Daybell and Lori Noreen Vallow. It does not say Alex. Why does it not say Alex? So let me go to the new one. Where Where's the new one? New one. The new one says, I thought they were,
I mean, he's supposed to be on
he
there
should have
too.
been. So
I do not know.
let me go find it. Let me go find it. Let me go find it.
Mm,
Oh, Vinny's going off about Colin.
mm.
All right, Nate. I love you, but daggone, you got a whole lot of 7. What are you laughing about?
You talking about
What?
Nate?
I love him, and I love all, especially when you're trying to go back and like look at it real quick because you didn't get to watch today. It's great to be able to read all this stuff. When I'm trying to find something, is not the time.
Right.
I think it was Pretty Lies that had it, that had the amended one up. Let's see. I wasn't saying nothing
Diamond
bad
Queen.
about your girl.
Hey, Diamond Queen. Good to see you. I know the, what do you call it? Nate is really good about like, I don't know. I think he just kind of like types it all up and then copies and pastes it over into Twitter, like boom, 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 boom. So he like gives several updates all at once.
He's really good.
Mm-hmm.
And like I said, when you're trying to go back and see what had happened for the day,
It's helpful. Yeah.
it's really good. But when I'm trying to, God bless you, I think, what was that?
It was a cough.
Okay. Then I take it back. Uh, I do that to Em all the time because she'll cough, 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 sneeze.
Oh, yeah.
Yeah, and she does it every single time. She'll start to cough, and she'll cough, 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 sneeze. But it's hard to tell, like, if it's a cough or a sneeze. And so I'm like, God bless you.
Maybe.
I think, what was that? Was that 1, 2, 3? Was that 1, 2? Was that 5? I don't know. Okay, Judge Boyce is coming back. Nate says, back in the courtroom, attorneys are at their tables. Judge Boyce is on the bench. Let's go, let's go, let's go. Lord. Oh, Lord. Lord. Oh, here it is. Here it is.
Oh,
Oh,
here he
he
is.
wasn't.
All right, I'm muted.
Thank you. Please be seated.
Oh, my gosh.
All right, we're back on the record on CR 22211623, State of Idaho versus Chad Guy Daybell. We took a recess after argument on continuing issues the court raised on the defendant's motion under Rule 29 for a judgment of acquittal, and in particular as it relates to count 4, after noting that the dates of count 4 in fact were dates that matched those in count 2 relating to the alleged murder of Tylee Ryan on JJ Vallow's count 4 dates. So the court allowed time for the state to research and further argue, as well as the defense. And the courts considered those arguments, and at this time we'll make a ruling as it relates to count 4 of the amended indictment. First thing I'll note is at the stage we're at this point is a ruling on criminal rule 29, which is for a judgment of acquittal. I already indicated the standard in the case law as it relates to the burden that the state has on that. I went through the other counts and denied the motion and reserved ruling on this count 4 for further research and consideration. The court having considered the arguments of the state and the defense, I'm going to rule as follows as it rules count for. First of all, the court would note that the state has argued that in its motion to amend the indictment, and I'll note the indictment initially was filed in this case May 25th of 2021. An amended indictment, which has governed this trial, was filed on February 20th of 2024. So there was a time frame between May of 2021 and February of 2024 where the governing charging document was the initial indictment filed in this case. The state, by motion in November of 2023, sought to amend the indictment, and the court went back and reviewed that motion to amend the indictment, and specifically leave was sought as required by the rule to amend counts 1, 3, and 5. And the court did have an objection filed, ultimately issued an order on December 8th of 2023 granting permission to amend the indictment. Among the charges sought to be amended, count 4 was not one of those. So when the amended indictment was filed, it did have an alteration on count 4. And so the court thinks it's important here to consider this procedural history. The original indictment on count 4 sets forth the dates of the alleged murder of JJ Vallow of honor between the 22nd and 23rd of September 2019. The state's argued then this is a clerical error that should be allowed to be cured, among other arguments. And looking at the history of the proceedings here, the court can make some conclusions. Number one, the court didn't permit or authorize any amendment to count 4 in the new amended indictment. So count 4 should not have been amended. Second, the dates that were put into the count 4 of the amended indictment of 8th and 9th of September 2019 mirror those dates of another count, count 2, which is the alleged murder of Tylee. Looking at that history, I think the court does believe it's a clerical error that led to the change of those dates. And so then the court has to consider whether or not there would be prejudice is one of the things I need to consider, the manner in which this could be fixed if it could, and whether or not there's any prejudice to the defense, which is always a big consideration and what the rules govern in seeking to protect due process rights of defendants. The court would note I also have to weigh that out with the right of the state to seek justice in a case with the charges it's filed. The state's argued it should be allowed to cure this, that it's a clerical error. The court notes that the defendant was on notice for a period of several years from May 25th up until that amended indictment in February of 2024. So nearly 3 years that the allegation was this murder of JJ had occurred on or between the 22nd and 23rd of September. In addition, the court would note that the evidence in the case all pointed to the dates of the 22nd and 23rd of September. And not only that, that same allegation's been made in a previous case that was tried last year by this court of co-defendant Lori Vallow with those dates. And of course, the defense here was aware of that trial, the evidence in that case, and a resulting conviction. So there's certainly no surprise that would come to the defense knowing that the dates that have been alleged are the 22nd and 23rd. So in terms of any prejudice, I wouldn't find that it would be prejudicial at this point to permit the amendment of the dates. The matter before the court now is just simply whether or not a Rule 29 motion could be granted, and then additionally, again, what could be done to correct this if it can be corrected. going back to count 4 of the amended indictment, if I were to disregard the dates in there, the court does find there's been sufficient evidence in terms of the elements that are alleged, that the defendant, Chad Guy Daybell, was identified by multiple witnesses, including Ron Arnold and Whitney Arnold, that in terms of the elements of the murder that are alleged, there was testimony from Brandon Boudreau and Garth Warren, among others, about this alleged count of first-degree murder involving JJ Vallow as a victim, and he was also identified by those witnesses, and then other testimony from numerous other witnesses that testified about the murder of JJ Vallow. In this case, lead the court to believe there's sufficient information under Rule 29 that the motion for judgment of acquittal would be denied on that. And then leaving for the last part of the analysis here, the dates, the court, having considered that history and the fact that count 4 just never should have been changed because there was no permission to do that, I do find it's an inadvertent mistake. I have also seen case law cited by the state that the actual date or time of is not necessarily a required element of the murder charge. So while these jurors have already heard the information contained in the amended indictment, the court believes that the jurors can be fairly and properly instructed with a curative instruction or some other manner in which to correct what they've heard, so they can properly be instructed in conformity with the evidence submitted. So the only determination the court makes here today is that the motion for judgment of acquittal as it relates to Rule 29 is going to be denied. And on one final point of that, I'll also mention that it was a matter the court raised itself. It's not specifically argued by the defense. And so the court again finds it's not prejudicial at this stage of the proceedings to allow for that change to occur. What I don't feel like I have had time to properly and fully ferret out on the issue is precisely how that will take place, whether it's through a allowance under Criminal Rule 36 has been suggested, an amendment to the charging document, or simply a curative jury instruction or explanatory jury instruction. I need some additional time to think about that. But for purposes of allowing the defense a fair opportunity to be prepared going forward with its case in chief, I am making the ruling that the Criminal Rule 29 motion on count 4 is denied. So the case will move forward. That count will be included in the court is going to issue a substantive follow-up order to the parties that will be directive in how the court thinks it's best to cure the mistaken dates in count 4. So that's the final ruling on the motion for judgment of acquittal. Ms. Beatty, do you have any questions about that ruling?
And Your Honor, do you need any further briefing from us or anything of that nature?
I don't believe I do at this time with the ruling made.
Thank you very much, Your Honor.
Any questions from the defense?
No, Judge, thank you.
Okay, thanks all for your consideration this afternoon. We'll be in recess until Monday morning for the defense case in chief to begin.
All rise.
Jesus, Jesus, Jesus. I feel like my
I told
whole
you I
head
thought
is
that's
about,
how he was going to be able to get around it.
I
Oh,
literally thought that my whole head was just going to come up off my shoulders.
I told you that was the only way he was going to be able to get around it, is to say that they did not have the right to amend that portion of the indictment. He can try to use it for appeal, Patricia, but really, I mean, I don't know. No one got in trouble. Somebody gonna get in trouble. Somebody, the Lemon Amendment. Oh my God, Margaret. Somebody's gonna be in trouble. Faux
The
show.
Lemon Amendment. Oh my God.
But thank you, Judge Boyce. If you're listening, we love you. We appreciate you. Because you know
Yeah.
Judge Boyce listens to the Crime Cafe. He is. He's listening.
Ah, ah. It'd be nice, but
Thank you, Jesus.
God.
The point that he brought up at the end is very, very, very important. It's something that I said before, which was, does it prejudice the defendant? And the fact that, and that this is where Pryor gets smacked right in his own face. Okay. Had Pryor not let it slide and wait for someone else to bring it up, if they would have rested their case and Pryor would have said, hey, I want to do my motion to whatever's, and I don't know why they do it in every single case, and I don't know why. I cannot ever remember what it's called, but to set
Directed
aside,
verdict.
directed verdict. Thank you. And also, by the way, there's a mistake in the indictment, so it would definitely go to count 4 because they haven't proven their case in chief because the data's wrong. He would have done that. Okay. The lemon jello typo. Oh my God, she's killing me. If he would have done that, then it might have held a little more weight. But because it was the judge that came up and said, there's a
Right.
little, and he had to, because he knew.
Yeah. Yeah.
And he's, he's bound by
He's a
that.
stand-up guy.
He is a stand-up guy, but he's bound by that. He is
Right.
bound to do that. The defense is not. But if he
Oh,
would
no.
have brought it up when they rested, he would have had more of a leg to stand on. So there you go. That's what happens when you act a fool. Pryor, if you're listening.
I'm just glad it's over with, and I'm glad that they. Whew,
Same, because I cannot.
God, could you imagine the rioting that would have began? Not literally. I mean, people, but
Maybe.
yeah, you never know. But man, I'm just glad for Larry and Kay, and
Is there a presser? Look for a presser. Is there a presser? Is
I
Nate
don't know.
talking?
I feel like I'm physically
I know. I'm tired.
exhausted.
Like,
That was so much. God.
um, and could you possibly have your microphone on this time if you do it, sir?
Oh, I know, right? Mm.
Why? Hi.
Hi. I don't see anything, but that don't mean that there ain't nothing getting ready to happen, you know?
Can you hear me?
Yeah, can you hear me?
I can now.
I'm looking. I don't see anything. East Idaho News. I'm looking
Oh my
there too.
gosh. Oh my
What?
gosh.
What?
Something's going on with my phone. It's not my phone this time. It's me going to a website that might have video playing and it trumps the feed to StreamYard. What I said was, for the 18th time, was that these people in the Karen Reed trial are so divided and going nuts. But
Mm.
Lucy just brought up a very good point. If he never played hockey, why he in a hockey club?
True.
Why was he fighting with people in a club called Hockey People? Why that? Why that, Colin? Why you in a club, Colin?
Oh.
I have a question for you. It has nothing to do with any of this. What shape nails do you do?
I go back and forth. I've done them all.
Almond?
I've done almond before, yeah.
Ugh. That is like the most popularist, and I just am not a fan.
I think the ones that I got before, my favoriteest ones were square, not necessarily squoval, but square.
Right. Okay.
Because I've always done like squoval.
Right.
But then I've done the stiletto or pointy or whatever you call them. I've done the coffin and almond, and the only ones
Coffin's
that I've
my
not
favorite.
done because I don't like them on me, period, is round.
Yeah, or duckbill. That's a whole
Yeah,
stupid thing.
yeah. I don't even qualify that
I think
as a
almond looks
shape.
so clunky. Coffin square's my favorite. So almond is like it's the new favorite. And when I think of almond, what I think is the old ladies when I was growing up, because that's what all the old ladies did when I was growing up, was that almond.
Yeah.
Now, see, Mickey Jor and I are probably close in age. We both like the square because that was all the rage when we were younger. But I'm not going to lie to you. I love that coffin. That coffin is fire. I didn't at first, but I've put it on and I like it. I like it.
I do like the coffin a lot.
I like the coffin.
Yeah.
Definitely. Now, when
Well,
they're shorter, it's a little harder to get.
yeah. You can't get that hardly because yeah, I know what you mean.
But Julian, I don't mean to sound rude, but you're across the pond, right? Because I wonder if that's like, because oval over here is not very popular. I had to change the tone for a minute. I'm sorry.
No, I'm appreciative of it. Literally feel like I'm just like ran a marathon.
I'm tired. I'm worn out. Almond shape, there's a little easier to work with for me, anyways. That's fair. Had nails done in 12 years or so, though. See, Mickey Jor. Okay, see, Mickey Jor. That's why. That's why you like the squares. I love square. I think it's great. Apparently, it's outdated. I don't care. Oh, you're in Canada. I knew you were in Canada. Okay, you're not across the pond. I knew you were in Canada. I knew that because I asked you that before. Okay. All right.
She's just across the border.
She across the border. She's not across the pond. I'm not dogging you, Mickey Jor, because I love me some square nails. The square, the better. Hey, Mary Lou. If I didn't
Hey,
say
Mary
hey.
Lou.
She is the bestest little angel ever.
Who?
Little Joe.
Oh yeah. What'd she ask how she's doing? She's doing good, Mary Lou. She's
the bestest kid ever.
She's I made her today out of toilet paper rolls, just the little cardboard tubes left,
Uh-huh.
I taped 2 of them together and made her little binoculars out of them.
Oh. Does she want binoculars? I'll send her binoculars.
No, she loves to do things with toilet paper rolls. She's like real big about she's
you can
real
do
big
painting.
into imagination station, like
you can
she's
paint with them, right?
Yeah.
You cut them and bend them in shapes and stuff and then dip them in the
Yeah.
I would have so much fun with her. Lord. I'm not gonna lie to you, my shoulder is aching right now because I hold my stress in my shoulders, and I was so, I mean, it always hurts, but it hurts a little more right now.
I understand. I know it was stressful evening, man.
I don't like it. I don't want it.
I don't want it either. I'm glad it's done and over with, though. And I'm telling you what, those prosecutors have one more time to screw something up before they're not going to be liked by me. That sounds real threatening, don't it? I won't watch you on Law and Crime anymore if you don't straighten up.
Yeah.
Take
quit.
that.
Go to 4 years behind court TV. Court TV didn't
Yeah.
even say nothing about this until the very end. Court
Oh,
TV, you're fired. Your tutu is in the mail. Okay?
yeah.
Okay.
A pink one.
Yeah.
And it ain't even going to be sparkly.
No, not at all. You get no sparkle and you get no fluff. It's just a sad skirt.
Yeah. And it probably won't even shake the wrinkles out of it. Nope.
No. We'll wad it up in a ball.
Mm-hmm.
2 strikes.
Yeah.
They on 2 strikes.
Sorry, I'm sitting here cross-stitching my stress away.
So we started to talk about it, and then I think they came back, or I interrupted, or I don't know, something like that. Anyways, so you're apparently doing well with it.
Oh, yeah.
So you've gotten
Yeah.
over it.
Yeah, I've got over the whole stamped colors being bright and things. I will say
It's
I
hard,
still have
right?
to like double and triple check, unlike some people I know. Um,
Who you
so
talking to?
the prosecution,
Oh yeah, you
double and
checking the
triple
cross
and
stitch,
quadruple
right?
checking stuff to make sure I don't make a mistake. And I'm talking about a flipping cross stitch, not a whole dang murder
Murder trial, yeah.
indictment charge.
So Nicole, because the defense doesn't have to say anything. He doesn't have to say anything. He was waiting for his chance. And he was just a little behind, because I think if he would have brought it up, that may have swayed Boyce. But yeah, he's not required to say anything. How did none of them, when they read the indictment, did nobody hear it?
I don't know. Nobody's paying attention. They all blocked it out. They're like, we don't have to, like, I don't pay attention to anyone. They're like, WD-40, BR-549. I mean,
Right?
I don't listen to any of that.
You know that's my grandma's cousin, right?
Yeah, you told me that from Hee
Just
Haw.
saying. Yep, Junior Sample.
That's
If
cute.
anybody even says BR, she's like, that's my cousin, right? My grandma.
BR-549.
We were just spelling breakfast. What are you talking about?
Breakfast.
She's like, BR, that's my cousin, right? I got his books and signed and all the things. What if they read the old indictment when they read the indictment? Kaylin, that's a good point. I don't know
You
if
know
they did it.
what?
Well,
I kind of want to go back. I kind of want to
I
go back
know.
to day one and see.
They would have had to have read it right, though, because he had made them change some things. So they would have had to have. That's a good point, though.
I don't know. I don't know. Well, youngins, I'm gonna call it. I'm done.
I'm done.
Done.
I was gonna say, if you speed watching, I'm out. Love you.
Yeah, I'm gonna change the title on this and change the thumbnail out. I'm not gonna leave it days 23 and 24 speed watch because nah.
I'm out.
I'm changing it, and we'll have to speed watch maybe over the weekend or something. I don't know. But
I'm ready for some more Karen Reed, y'all. Mm.
And then Daybell's not even having trial tomorrow, right? They're done till Monday.
Yep, they're done till Monday. So we'll
No
get
court
caught
on
up.
Friday. Look at that.
Go figure. Maybe we should send an email.
Patricia says you got
ahead.
2 strikes, prosecutors. Yeah, Chaloon, yeah, it's a self-care kind of day, right?
Day's almost over.
Yeah, I still have one more stream to manage, so
Oh Lord,
it's Thursday.
you do.
Yep. Patricia wants to work for the courts in
Yeah.
Canton. I want that schedule,
Facts.
right? I like that schedule, but then could you imagine being able to work with the people that sound like that all day, every day? I would eat that up.
Okay. Alternatively, though, could you imagine having to work for Aunt Bev or Lally? Or
I can't tolerate Lally
I cannot.
as far as Bev goes, she doesn't bother me. I mean, yeah, she might be a little bit biasy or whatever,
A little
probably.
bit.
Okay, a
Man.
whole lot.
And a control
whole
freak
lot.
much.
A
She
whole
has
lot.
to instruct the entire defense team on how to do the things and how to get things into evidence because she's the only one that does it that way.
You're right. You're right. She's a
Sorry.
whole lot. But yeah, her
Patricia,
chair
you ain't
bothers
wrong,
me.
Doc.
Her chair bothers me more than she does.
Facts. Look, y'all, I sent a whole Amazon order. I sent them Kleenex, I sent them Claritin, I sent them some Ricolas, and I sent a whole case of WD-40, and that mess got lost. Can you believe that?
Mm-hmm.
Now, y'all know I'll be sending stuff with Amazon, right?
Right. I love that because it's free shipping. Patricia
Pretty
says
lies.
Patricia said when that guy kept saying Doc during
Yeah,
his
Doc.
testimony today, I was
Yeah,
loving
it
it.
was Doc. Pretty lies just said I do not even want to know what my blood pressure is right now.
Yeah, right. I mean, I
Thanks.
literally felt like my head was going to come up off my shoulders.
Thanks.
Well, I can
I need a
guarantee
nap.
you that Kay and Larry are celebrating right now. So,
Wait a minute. What did Lori say was her dates as Chad's? Wait, what? Hers were probably right. I can't remember what happened that they had to take the death penalty off. I know that was an error on the
it
prosecution's part.
had something, I don't know exactly, but I do know that it had something to do with them doing something to do about a speedy trial waive and them saying that they didn't have enough time to I think that there was a time limit for exculpatory
Charging
evidence
for
to come
charging
in
probably.
and things got sent in past the deadline or something. And so because of that, they dropped she didn't waive her right to a speedy trial. Okay.
Yeah.
And because of that, they
took too
didn't have
long,
enough
so then they
time to
had to,
get
okay.
the evidence in.
Got you. Okay. I think they should have tried harder.
Yeah.
All right. Well, I'm going to jump down so you can do your Southern goodbye because otherwise we'll be up here all day.
Yeah, it ain't gonna be much of a Southern goodbye.
I know.
I'm ready to I love you guys so much. And I love that you guys spend all your time with me all day, every day. I appreciate it and I love you.
But she's done with y'all.
I'm not done with y'all. I'm just
You're done.
I'm done for today. That was so much stress in a very short amount of time.
It was. All right. I'm jumping down. Love you.
Love you, QB. Thank you
Bye,
for coming up here.
y'all. You're welcome. Thanks for having me.
Always, always, and forever.
Bye, y'all.
Bye. Yeah. That was a lot, right, guys? Oh, man. At least we can breathe, and at least we know that all's good in the hood. All's good in the hood. Judge Boyce has your back, JJ. Judge Boyce has your back. All right. So, like I said, I do appreciate that you guys come and hang out with me every day. I mean, most of y'all are in here from morning till night, and I love you for it. QB, we'll do 11. Yep. Because I'll be up late tonight. So, yeah, we'll do 11. It was a lot today. It was a lot. F1 weekend for me. What's F1 weekend mean? What does F1 weekend mean, Henny? Oh, Formula One. Got you. Vroom. Okay. Got you. Makes sense. Yeah. I'll be on and off tomorrow, Formula One. Yeah. Zoom. All right. Okay. Well, thank you as always. I appreciate it. I love you guys. I'm going to go speak to the husband because I know he's like, what in the world's going on? Because he could tell whenever he came in a while ago that I was like, do not speak. Because I was listening, and he came in and I looked at him and like put my hush face on, like my shh, don't say nothing face. So I know he's like, uh-oh, something's not good. So I'm going to go talk to him, figure out dinner, and then I have another stream later tonight. So I will see you guys at 11 in the morning for Karen Reed, and probably plan to get a little bit more caught up with JJ Daybell over the weekend, kind of like we did last weekend. Speed through, but I do need to remind myself I need to go right now and change the thumbnail on this video and the title because that's not what had happened, right? All right. Love you guys, and I'll see you at 11 in the morning Eastern Standard Time. Okay?